Morning. So, morning, everybody. Welcome to another episode of PLA with myself, Nick and Bruno. We've got one question for each of our experts today. Bruno, we're going to start with a question with you. It's more of I think, a topic than a question, really, something to actually discuss. We've been receiving a lot of questions surrounding the criminal status of tenants, right? Whether it be one that's discovered once the tenant is already in occupation or whatever the case may be. But the question really is around vetting expectations and whose responsibility is it, right? Are there any obligations that are in legislation? And then once maybe a landlord discovers that the tenant is a criminal, or is a criminal by nature, or is conducting criminal activity on the premises, what are the rights regarding termination of those leases? So perhaps from a perspective of estate agents, tenants, and landlords, perhaps just discuss there quickly what the vetting expectations are.
Sure. So to begin with, there's a distinction that I need to make between what procuring is and what management is. And so obviously from an agency perspective, these are two very different functions. So the management of a property can even be undertaken with an existing tenant there, and you get approached by a landlord to say that somebody's staying on the property at this moment, and you expect someone to send them invoices, collect rentals, do inspections, that sort of thing. That's a management component. Procurement component is when the agency is mandated or instructed by a landlord to acquire a tenant for the property. So these are two very specific functions, and unfortunately sometimes these these two functions are blurred, simply because the same agent that will be procuring a tenant will also be the same agent that will be managing the property. Most of the agents that I work with, I do try and emphasize the importance of distinguishing between these two functions, simply for their own sake, because from a mandate perspective, from an earning potential perspective, these earnings look different. And if you ignore the procurement in favor of the management, you need to then make sure that your management mandate is rock solid, that people can't easily get out of it. And if they do get out of it, that you somehow get compensated for having procured the tenant to begin with. So that's a full conversation for another day, though, because it does get quite comprehensive. But it is important that an agent almost wears two different hats when dealing with this. So from a procurement perspective, in an instruction or in a mandate, when a landlord comes to you, there's certain basic requirements for this mandate to say, look, I have a property, I've got an expectation of receiving a certain rental amount. That's the first part of the mandate. The second part of the mandate would be, I expect there to be a tenant placed on the property. Now, there's also an implied portion to this mandate to say that the quality of the tenant also needs to be acceptable, right? It's not simply a matter of putting anyone into this property simply for the promise of paying. So it has been implied, and is an industry norm, that to a certain degree, an estate agent will be responsible for somehow vetting the tenant. And this is now expectation, it's a norm. No one would, because what you find sometimes, sorry, just to backtrack, what you find sometimes is some agencies don't have these mandates in writing. So the question as to the specific terms of the mandate are always up in the air, because no one quite understands to what extent an agent was supposed to do what the agent was supposed to do. So when you look at certain tacit terms of a mandate, it is, while you're supposed to listen to the landlord, you're not supposed to enter the mandate, the lease on my behalf. My mandate or power of attorney doesn't extend for you to sign the lease. All you need to do is find me a tenant at the rental expectation that I deem appropriate, right? And this has to be a suitable tenant. So those are very basic kind of things that I would say from an industry perspective that one would expect. Now, if you take it one step further, the right thing to do would be for the agent to actually set out the terms of this mandate properly, to say, well, How far do you want me to go? What is the price you're going to pay me for procuring this, this agent? What happens if this tenant? What happens if I find someone willing to pay more? What happens if I find someone willing to pay less? What happens if in 2 months' time you land up contracting with this person anyway? Do I earn? Do I not earn? So most mandates should actually then go further to define these different contingencies. But what they rarely ever detail is what the expectation is of an agent to vet. So what is an appropriate tenant, and how far is someone going to go? And this question came behind this need to do a criminal check for tenants, and whether this is now an industry norm that when an agent vets tenants that they have to do criminal checks. And why this is a problem is, number one, sometimes the consent that's being signed by the specific tenant doesn't provide for such an extensive search. So that's one thing to consider, is if this is a requirement, the tenant also needs to confirm that they're giving their consent to go this far into it. The vetting process sometimes involves looking into bank accounts, looking into the balances in the bank accounts, payment affordability, but looking at very personal information that the tenant might not even realize that you have access to because of now the systems that we have to do these searches. And especially now with the criminal check, you have to ask yourself, is the tenant, or rather, is the estate agent expected to do the criminal check? And the problem is there is no set rule on whether they are or aren't, because a criminal check does not necessarily mean that the person doesn't have affordability or aren't willing to pay. A criminal check, for example, because the person drove drunk, is very different from a person that might, for example, have been convicted for dishonesty or theft of monies or something along those lines. So, even the criminal check in itself doesn't necessarily set this rule about who is allowed onto the property or not. So it's very important, I feel, nowadays for agents to properly define in their mandate, even by list, saying these are the searches. I mean, it's very simple to do this because, I mean, most agencies actually use TPN as an example. So most of them would actually be able to jump onto TPN, see the variety of searches, see the cost of these searches, and list them in the mandate to say, these are the searches, these are the costs. We only charge the tenant X amount as an administration fee because this is all they're normally willing to pay. If you want to go one step further, cool, no worries. Tick these boxes here. We'll get the consent from the tenant, but there might be an additional cost or something along those lines. So I wouldn't leave it to chance to go, is it a requirement to do a criminal check? Because there is no yes or no answer. It really depends on what you represented to the landlord. I would err on the side of caution and say, list what you can do and what you can't do, and let the landlord then choose it and possibly even contribute towards it if there's a cost component.
Well, so that they have it. So thank you very much there, Bruno. So that clears up at least a lot of the questions that we've been getting around the criminal status of tenants and termination of leases, and the general vetting expectations as to whose side they fall on, and of course going further as to who would actually have to pay the costs if such searches need to be done. So thank you.